year 1966 with a generous donation from Dr. Tamappanna Kausali. The institution was established with a view of educating the rural and urban youth of surrounding areas. But today, we are proud to say KLE Society, being the prestigious and largest educational society not only in India but also spread across global level under the dynamic leadership of our Honorable Chairman Dr. Prabhakar B. Koreji. Our alumni are sprawled through the world in different fields. Ladies and gentlemen, KLE Society is not just concentrating on excellent academics but also works for societal welfare and create social awareness among people. Today, we are back with another workshop. We have Shri Vikramaditya Chavan sir with us as a resource person. I now request Srimati Prabha Munvalli Madam, HOD of Political Science Department and convener of today's workshop, to welcome the delegates and introduce the resource person. Over to you, Madam.
Good afternoon, all. I am Prabha Munvalli, Department of Political Science. Dear delegates, we have been coming across the halla-balla of advanced countries regarding intellectual property rights. All the underdeveloped countries are struggling to protect their intellectual property rights. In order to have a clear and in-depth understanding of the topic, this workshop has been organized. First of all, on behalf of all, I extend a warm welcome to the president of today's workshop, Dr. Umar Nerle Madam, our principal. Welcome, Madam.
Thank you.
On behalf of management, KLE Society, teaching, non-teaching staff, and students, I extend a hearty welcome to today's resource person, Shri Vikramaditya Chavan sir, Senior Associate, Nayak and Company, Mumbai. I am happy to welcome all our delegates, teaching, non-teaching staff, and all my students. Welcome you all. On this occasion, I deem it a privilege to introduce today's resource person, Shri Vikramaditya sir, an intellectual personality. Sir has completed his law graduation at DES Navalmal Florida Law College in Pune and diplomas in intellectual property and media laws from Symbiosis Law School and Nalsar University of Law, respectively. And he has also completed the copyright exports offered by Harvard University. Copyright law is one of his key areas of interest and practice. He has started his career in IP boutique firm and dealt issues relating to IP protection and advisory. Presently, he is serving in the litigation team at Nayak and Company as a senior associate and dealing with disputes relating to media and entertainment industry, including intellectual property disputes, especially copyrights and commercial matters. Once again, I welcome you all. Stay home, stay safe. Thank you.
Thank you, Madam. Intellectual property, more than ever, is a line drawn around information, which asserts that despite having been set loose in the world and having inevitably been created out of an individual's relationship with the world, that information retains some connection with its author that allows person some control over how it is replicated and used. In other words, the claim that lies beneath the notion of intellectual property is similar or identical to the one that underpins notion of privacy. It seems that the two are inseparable because they are fundamentally aspects of the same issue. The need to ring fence certain information is what intellectual property rights speaks of. To get better knowledge of intellectual property rights, I request our today's resource person, Shri Vikramaditya Chauhan sir, to take over the mic for the presentation. Over to you, sir.
Thank you so much for the introduction. I'll be sharing my screen. I'll be sharing a presentation that I've prepared for today's lecture.
Yes.
Yes, sir.
I hope my screen is visible to everyone.
Yes, sir.
Yes, sir. It is.
Firstly, thank you for the introduction. As has already been introduced, I've been working on intellectual property matters for the last 6 years. And of course, it's been a very important aspect in my career. And the importance of IP in today's world is growing as since since globalization has happened, things have changed, and over time, the importance of intellectual property has grown. So let me start with the first slide, which where I'll deal with the types of intellectual property. Before going into details, I'd like to just go through the different types, because these are words which we've heard somewhere in our life, and we may not know that all of them come under the umbrella of intellectual property. So trademarks, names of companies, names of brands. This is one very important aspect of intellectual property. Second is copyrights. We keep hearing about film remakes of films. The rights that are contained in a film or in a book. So that is what comes under copyrights. Patents is very important. It basically deals with inventions, innovations, processes. So that's another important aspect. Fourth is designs. Designs is the aesthetic value and the overall look and feel of a product, which is protectable under designs. Then is trade secrets, geographical indications, plant varieties. So these are different types of intellectual property. Of course, intellectual property has grown to become a very big field of practice, not only for lawyers, but for people who are studying engineering, people who are studying science, people who are in the fields of art. So it has grown to a certain extent. And of course, my field, my area of expertise has always been the first two, that is trademarks and copyrights, which I'll be dealing with more in detail compared to the others. But again, before I go into each aspect in detail, let's understand what are intellectual property rights. So what is this intellectual property rights? So as we understand, property rights or property is something that we all understand, because land, for example, or your house, your flat, these are all property rights which you can see, you can feel, you can touch a property, you can it's something that is tangible. But these particular rights, intellectual property rights, are intangible rights because they can't be seen, felt, or touched. So that is one the first aspect of it. Second is that these are all products of the human intellect. A property, a land, is not something that has been created. However, this comes to existence. The intellectual property rights come into existence because someone has thought about it, put efforts into creating something. So that is something I'd like to emphasize on, which is intellectual property rights being the products of human intellect. And thirdly, like any other property, intellectual property rights are commercially valuable property. That is, they can be bought, they can be sold. So similarly, film rights can be sold. The goodwill in a trademark and the trademark itself can be sold or assigned. which is the right terminology which should be used. So this is what when you consider them overall, this is what intellectual property rights are. Going into what is the purpose, why do we need intellectual property rights? First and foremost, to award the creator for the work he's done, for his labor. So it's very important that these rights which are created, there should be some reward for it. And that is the reason why we have laws in place. That is the reason why there is a Trademarks Act, there is a Patents Act, there is a Designs Act, which deal with the details of how long, which will come to one by one. But it deals with the details of what exactly royalty is, what exactly is the whole value that intellectual property creates. Second is to ensure economic and social advancement. Of course, for the economic growth of the country, for foreign investment to come in. International technology transfer, protection of a country's natural resources, and public health. So intellectual property has grown over the years. There are geographical indications, which is one of the different types, which is a way by which a country can file for an intellectual property in one of its geographical indications. For example, the turmeric or Kolhapuri chappal in Kolhapur in Maharashtra is one of the geographical indications. So these are things which have grown over time, and they have been recognized through intellectual property. Of course, technology transfer or technology is another way by which a country's resources or a country's economic significance will always increase, because a country, a company which owns certain technology in which they've put in a certain amount of research and development and investment. So that particular company which has put all the resources into developing something new and something innovative should have something more than, so a process or a product which has been developed by the company, by that particular company, should not just go to others for free. There should be a reward for that particular research and development that has been put in by the company. So that is the main understanding or the purpose of why this intellectual property needs to be separately protected, and why the gist of which being that someone who has created something, another person should not be able to just ride on the goodwill and reputation of the other person, and the main creator should be able to be awarded for his labor. That's one of the most important things here. So now, after having given you a background of what intellectual property is, we can deal with all of them one by one. Trademarks, which is a very well-known field of IP, which a lot of us, commonly understand. A lot of us deal with it in our day-to-day lives as well. We come across several companies, several brands, which are all in the end trademark protectable. So understanding from what a trademark is a mark which is capable of being graphically represented. So the first and foremost important thing is that it should be able to be graphically represented. Now, what are the categories? It can be a word like Kodak, Apple, Reliance, a logo like the Mercedes-Benz 3-star logo that I've put in the slide, a signature. So various celebrities like Sachin Tendulkar and Shah Rukh Khan have also filed trademark applications and obtained registration for their signatures. Shape of goods, particularly if the shape of something, for example, the Toblerone chocolate or the Ferrero Rocher chocolate, these particularly have a specific shape which have become so famous or so well known that anyone who sees that particular shape is taken back to that particular brand. So even shape of goods can be an indicator of where those goods are coming from. Of course, this has happened over time, where because it's become so famous that it's gained popularity, and uh, therefore these particular chocolates have the specific shapes which you can call them as trademarks today. Then of course labels, packaging, combination of colors, sound marks, the intel inside the 3-chord tune which plays. So that's something we've heard in advertisements, etc., or when earlier when the desktops were there, when we would switch on our PC, that intel inside tune would play. So whenever you hear the tune, it takes you back to that company, it reminds you of the company intel inside, and that's the reason why trademark sound marks are also very important. And of course, a combination of a word and a logo, or any of the above, would be something which is called as a composite mark. So coming back to trademarks should be capable of being represented graphically. Secondly, they should be capable of distinguishing the goods and or services of one person from the other. So that's very important. So I can't adopt a trademark which is already being used by someone else. It should be something unique. It should be something that is identifiable with me, and it distinguishes the goods and services of me with others. So it should not be generic. So these are some of the basics of trademarks, and just to give you an overview of what a trademark is. So going into adoption of a trademark, it's important before you adopt a trademark, before you start a company, before you start your own brand. It's very important that there are certain points that you need to keep in mind before doing that, and so that you stay within the purview of the law, and so that there is no confusion, there is no passing off, which can cause trouble in the future. So the points are that the mark must be distinctive. So in that case, it's very important that the mark should be something distinctive. A good example of a distinctive mark is a coined word. So as we've seen earlier, Kodak for cameras, Kodak is a word which does not have any meaning as such. It's not from the English dictionary. Now, an interesting thing is that the makers of Kodak actually came up with the name because they heard the click of the camera. And that click is what sounds like the word Kodak. And that's how they ended up naming it Kodak. So it is something like a coined or an invented word, which is distinctive because no one else has come up with that. And that is the best kind of a trademark. So when you're starting a company, it would always be recommended that a coined or an invented word would be something which is distinctive, and that would be one of the best words to be adopted as a trademark. And second is arbitrary to the goods and services. So whatever goods and services that you are particularly providing as a company, that word should not be connected to that in any way. Now, if I have a business of selling apples, I can't name my own company Apple, because in that case it would be describing the goods as it is, because that is my business. However, if it is for electronics, then in that case Apple would be a good trademark. As we all know, the famous company Apple has already used this strategy. So this is a very important thing. Secondly, it must not be descriptive. I think I've already covered that, descriptive of the goods and services. Then it must not be identical or deceptively similar to any other mark. So in such a case, a proper trademark search needs to be conducted through a trademark firm or an attorney who will help you identify any marks which are already on the register which are similar. You may have coined a word or invented a word, but someone else may have thought of that and filed an application for registration. So in that case, it is important for you to ensure that there's no overlap. And lastly, a mark which is not offensive, which does not hurt any religious sentiments, or which is not against the Emblems and Emblems Act, etc. So there are various other things also, which of course will going through the Trademarks Act will give you a better understanding of this. Going forward, the registration of trademarks is very important. So the main reasons for that is that when you get your trademark registered, it is the protection of the brand value or goodwill of the company and or product. So of course, when you register your trademark, you're creating an intellectual property. Your intellectual property will have some value. There'll be a valuation of the IP will be done, and of course, when the trademark is being sold or assigned, there'll be a typical consideration that you will receive, or whether it's a brand. So in that case, it's very important to have your registration in place. Otherwise, it becomes more difficult in that sense to apply for maybe if someone else is infringing your mark, if someone else is using a similar mark, then in that case, it becomes more difficult for you to protect your trademark. And if you don't have registration, you'll have to go under other common law aspects like passing off to protect your mark. But registration is something which is very important in that sense to protect your brand value or goodwill. Secondly, stopping others from using the same or deceptively similar mark. Of course, when you have registered it, and if someone else tries to register a similar mark and they do a trademark search, then in that case, your trademark will pop up in those searches, and that will also obviously help you in protecting your mark. Thirdly, helps in commercialization of the brand. As I already said, that the brand, the value, the goodwill, and the reputation that the brand has itself earned is also of some monetary value, and that will also always help in the overall commercialization of the brand. And lastly, the registration sign, the R sign, always helps you when it comes to it gives you a direct indication that the mark is registered. So any infringer who may even try to think of adopting something similar may just, it's like a red signal for him that, okay, this trademark is registered in that sense. So it's registration of trademarks is therefore very important in that case. Going forward, we've understood trademarks in a basic sense. But going forward, we need to understand what is a copyright. Copyright is also a very important aspect of intellectual property, but it is very different from everything else, because all these different aspects of intellectual properties protect different types of rights. So copyright is something which protects different categories of work. First one being literary, dramatic, musical, and artistic works. Literary works being your books, poems, etc. Dramatic works being plays, musical work, the graphical notations that you would write in staff notation format, artistic works, your paintings, drawings, etc. And even software applications are considered to be a part of the literary works under copyright. So these are some very important aspects of copyright, which this is a very important category of copyright. Secondly, cinematograph films. The film in general, which will contain some of the above categories as well, because a film will have literary work, it will have dramatic work, it will have musical work, artistic work. So everything coming together, the film itself is also protectable separately under a copyright. And lastly is the sound recordings. Sound recordings would be the final product, the final master, the copy of the recorded material wherein the lyrics of the song have been sung by an artist and the musician has played the music, and the final product is the sound recording, which is also separately protectable. It's also important to know what does copyright, what does it not protect? First important thing is facts. Anything which is factual cannot be protected under copyright. If a particular news event has taken place recently, that particular news event will not be cannot be protected under copyright. Ideas, today if I have an idea to start something, to maybe start a food delivery app, that idea per se cannot be protectable. Concepts and information in public domain. If each of these works has a particular amount or a period of time after which the copyright ceases to exist and the work comes in public domain. For example, as you can see on the slide, cinematograph films is 60 years post the publication of the film. So after these 60 years are over, the film comes into public domain. So any material which is in the public domain will not be protectable in that sense. However, copyright will protect the expression of all of this. So even if it's a fact, even if it's an idea, if it's a concept, if, for example, I have a concept for starting a TV show, and if I have expressed that concept in a very particular way, then in that case, I will get copyright protection over it. If it's a fact, if it's something factual, but I have written a beautiful news article about it, and I've written it in a very specific way, I've detailed it, I have given instances, in that case, it will be protectable under copyright. So also it is very important that unlike other forms of IP, copyright is set to come into existence as soon as it is created. So that is why, as such, copyright registration is not compulsory. So that's how copyright is different as compared to the other fields of IP. Going forward, the ownership of copyright is very important. A first owner of copyright. Now, in terms of different categories of work, for example, for literary work, the person who writes the literary work, the author of the work, is considered as the first owner of copyright. Musical work, again, the author or the musician who writes the musical notations. Artistic work, a painter or artist who creates the painting. Software applications, an author of the work, the person who writes the code. Films, the producer of the film, and sound recording, the producer of the sound recording. So why this is important to know who the owner of the copyright is, or who the first owner of the copyright is because at some point when any of the students or any of you decide to actually work somewhere or are creating something, it's very important to know that there is an exception to the above, to being a first owner, and the main exception is that work created under a contract of service. So if you are creating any work under a contract of service, under employment, then in that case, the owner of the copyright will not be you. In that case, the owner of the copyright will be your employer. So this is very important. So like an example I had given you earlier about how companies will get a lot of people to do their research and development. So in that case, the particular people who have been appointed by the company to do this research, to write all these particular things, to compile all the information. So whatever copyright is there that has been created will be owned by the company, because it is in that sense, or the reason why this provision exists is in that sense that all this work, everything has been done at the instance of the company, and the company has put in its resources. The company has provided the best labs or the best research facilities or the best resources in general for this to happen. So that is one of the reasons why these provisions exist. Again, coming to registration of copyright, registration of copyright as per the Copyright Act is not expressly stated to be compulsory. However, of course, it is very important for you to do it in that sense, because whenever your copyright is infringed, if someone is affecting your copyright or is using your copyrighted work without your permission, then in that case, if you approach a court of law with a certificate of copyright registration, it will always be more helpful as compared to you going without any certificate in that sense. So that is one of the reasons why registration is important. So registration compared to the others, other fields of IP such as trademarks and patents, registration does not have to be done through an agent or a lawyer. The registration can be done through, it can be done by the person himself. Any person can go on the copyright website, the details of which are on the screen, copyright.gov.in. Anyone can go on this website and create an account and follow the steps. Detailed guidelines have been given by the Copyright Office to understand the procedure, and applications can be filed, whether it is just to file a copyright application for a poem or even a song or a musical work. This can be done directly by you by following the procedure properly. Of course, there are other ways to do it, like you can go through an advocate's office or through one of these agents. But the whole process has been explained. Coming to the stages of copyright registration, firstly, it's very important for you to identify what is the work. For example, in case of software applications, you may want to file a copyright application for software applications, but at the same time, you want to protect the different layout and the artistic work separately under a separate application for artistic work. So all these small things need to be understood about what are the different ways that you can protect your work in. And once you've collated the necessary material, which the details of which are available on the website, then you can go ahead with filing the application. And there are, of course, different stages that your application will go through. And the end result will be an acceptance or a rejection from the Copyright Office. Coming to the next slide is infringement of copyright. So a copyright is infringed when any person, without obtaining permission, does anything which the exclusive right to do under the Copyright Act is with the owner of copyright. So to keep it simple, you have to, if someone owns a copyright in anything, you have to take their permission, whether it's a song, whether it's a book. If you wish to use it for any purpose, whether it's commercial or not, it is important for you to ensure that you have taken the requisite permission, paid the requisite license fee, or of course, if the copyright owner is okay with you using that work without any license fee, then in that case, of course, you can go ahead and use it. So these are things which are very simple. I don't want to go more into the technical details of this. So that's basically what infringement of a copyright is. What are the different ways in which it can be infringed? There's direct copying, where your DVDs, pirated DVDs of films and copies of software were being sold. It was very rampant in the 2000s, where there were these DVDs with movies and even software which were being sold very often. Now, of course, it's been taken over by torrents, where you can directly download it online. But this is obviously a form of direct copying where the work is as it is being copied. Indirect copying is if someone reads a book and he makes a play out of the book without taking permission from the original book writer, or a play into a film or a book into a film. So these are indirect copying where you're not taking things verbatim, but you're taking the essence of the play or the book and turning it into and putting it in a different form. Subconscious copying is also an infringement of copyright. This happens in with musicians, because musicians listen to different types of music, different genres, and different uh, artists. So in that case, sometimes what happens is that when they are creating the music, they may subconsciously just write just end up picking something up from what they've heard, and only when the actual author of the musical piece recognizes it is when a suit is filed and things get serious. So this is also another form of infringement. Piracy, as we all know it, piracy is also another form of infringement. So, of course, there are not only civil but also criminal remedies available under the Copyright Act. So, a criminal complaint can also be filed for infringement of copyright. Different forms of piracy, as we already discussed. So, there are different forms. I've given you the example of how the DVDs and etc. were being sold. Of course, there are books also, which unofficial copies are sold. They're printed on cheaper paper and sold in stacks on the streets. So this is also very rampant. And music was being. There was a time where there were various softwares through which you could download the particular song of your choice. And although now things have become better with the streaming platforms, but infringement of the copyright in music was something which was very rampant and continues to be today as well. These are just some examples, just of how rampant it had become at one point, of how these DVDs were sold and games were being sold in the market. This is an example of Pirate Bay, which was one of the torrent websites through which a lot of illegal downloading of work of copyrighted material was being done. Yeah, so that was on copyright. So we've understood two important aspects of intellectual property, which is trademarks and copyrights. The third one being designs. So designs or industrial designs is a form of IP that protects the aesthetic features. Now the features of shape, configuration, pattern, etc. Particularly these things are protected under a different aspect of IP, which is designs. Now this is not just functional elements, which we'll come to later, which will be protectable under patents, which have a typical function. But this is just the overall look and feel of a product, which can be protected under design. Now, for designs, it is very important that the article should be new or original. It should be capable of being applied to an article and should appeal to the eye. So this is one of the requirements. So by new or original, it also means that it should not have been disclosed in the public ever. It should be so novel and so new that it's not disclosed anywhere by publication in any form whatsoever. So these are some of the requirements under the Designs Act as well. So this is when it comes to designs, these are some important points. Also that it should be significantly distinguishable from known designs or combination of known designs. So it's not that you pick up one or two designs and combine them and file an application. That is something which obviously will be refused in that sense. It should not comprise of any scandalous or obscene material. It should not be contrary to public order or morality, not prejudicial to the security of India. So these are also some important parts of the Designs Act. And lastly, the term of protection for designs is 10 years. And after the expiry of 10 years, it can be renewable for another 5 years. So this is, the overall understanding of designs. Now coming to something which is related to designs, and it is towards the more scientific sides, while designs was more towards the look and the appeal that it gives to the eye. The next aspect, patents, is one of the most important intellectual property rights. And to understand it, there are two basic types of patents, which is a product and process patents. And for any patent to be given protection, it should pass the criteria of novelty, inventive step, and industrial applicability. So, considering them one by one, of course, novelty, it should be something new, just like designs. It should not be something which is which has been previously patented, or it's been in the public domain for a very long time. It should be something novel. It should have an inventive step. There should be some invention. Non-obviousness is the criteria that is usually used. Of course, I'm not a patent practitioner myself, so this is more of a basic overview that I'm giving you. And third is that it should have an industrial applicability. So in the end, a patent, the ultimate goal should be that it should be applicable in an industry. So these are the three main, this is basically the basic criteria of for patents. Going forward, the different types, the product, apparatus, system, device. So a product patent is the final product. So you can apply for a product patent and you will get your patent for the final product which you've invented or created. But you can also apply for a process patent on how that product was created or on how a certain process works. So maybe the product may not be patentable. It may have been patented back in the day, but you found another way to create it which is faster than someone else. So that process can also be patented separately. And of course, these are the important types of patents. There are certain things that are excluded, such as business methods, etc., which cannot be patented in that sense. And lastly, the term of protection for patents is about 20 years. So this is a basic understanding of how patents. So just a few examples of designs and patents. So for designs, if you see the Crocs, the particular shoe that is here on the screen. So now compared to the usual footwear, this is something which is different, which has a particular design, which has a appeal to the eye, which before this may not have been created by anyone else. So this is a good example of a design. Of course, now you can see these on these particular cars which are there. So these are by a company called Doms. Now these are all erasers, but they are in this particular shape. So these again would be entitled to design protection. So these are just two examples I wanted to show you, to understand what designs are. And for patents, I'd like to show you another example of a very regular thing, which is a razor blade. Now, Gillette has a countless number of patents just for the razor blade, because it's something which they have researched and developed over the years. And there have been different, now if you see each, like the trimmer blade, the pivot mechanism, each thing has been separately patented by them. So the razor handle, and of course, some of these features which have aesthetic value will be under design protection, but the rest of them have some of them, for example, the pivot mechanism. These things were created by Gillette. So these are all different things which have been, patented. So that's why this is how patents are or intellectual property I may say is has been a part of our daily lives over the years, and it's that's one of the reasons why it is so important. Lastly, I'd like to come to trade secrets. Now there may be some things which don't fall under the usual garb of IP. If something is not following in under patents or under trademarks or copyrights, and there's no other way to protect them, so the only way to do it in that sense is to just protect it, just keep it a secret, because even patents after a point, after 20 years, will be in the public domain. But there are some things which you can just keep them as a secret. So two good examples of these trade secrets are the KFC recipe, which is kept as a trade secret till date, and the Coca-Cola, the formula of Coca-Cola as well has been kept a secret. So these are two of the most common examples that I could think of for trade secrets. I think I come to the end of my presentation. So I hope you've gathered and understood the different aspects of intellectual property. And I'll be happy to answer any questions if there are any.
Thank you, sir. I think sir elaborated well in a very short time. Of course, the creator needs to be rewarded. It shows even if your invented word doesn't have any meaning, make sure it's distinctive, just like Kodak. Put all your creativity and own it as yours. So we have some questions in the chat box, sir. I'll read it for you. The
Sure.
first question is, what is the difference between trademark and brand?
So trademark and brand is not something that needs to be distinguished. A brand is a name that we usually give to, for example, a Nike or a Adidas. So these are just brands. These are just names. This is just a general sense of the word. But a trademark is when you protect that brand, is how you protect it under the Trademarks Act. So in that sense, there's no comparison of the two. But a trademark is a form of intellectual property, and a brand is just a general word given to a particular commodity. I would say that's the best way to put it.
That was asked by Amit. And the next question is, trademark registration is done nationwide or international, or even local trademark registration is possible, by Shashank Hegde.
Yeah. So the trademark registration is done nationwide. So of course, if you file for a trademark registration in India, you will get protection only in India. But there are ways, of course, instead, it obviously becomes difficult to file in many different countries. So in that case, there are ways to do that. There is something called the Madrid Protocol, through which you can file an application where through India, and it can reach out to different offices around the world. So these are all different treaties, the Madrid, through which different countries have come together so that IP can be protected on a more nationwide basis. Of course, through a proper law firm, these things can be done in a proper manner.
Okay, thank you, sir. Next question is, how many year patent of crop variety under Patent Act, asked by Jnaneshwar?
Plant Varieties Act is something which I think he's referring to, but that's not something from my areas of expertise. So I think I'll have to skip that question.
Okay. The next question is, what are the different IP rights in e-commerce and how to obtain them? By Subhash Patil.
In e-commerce.
Yes.
So if you're planning to maybe start an e-commerce platform, uh, the basic things that you would require would be uh, the basic things that you would require, of course, would be a trademark registration, because you would want to be like a Flipkart or an Amazon, and you want to be known, you want to protect your brand, your image, your company name. So in that sense, a trademark protection would be required. If you have any particular software which you're using, or some algorithms which you are using, then in that sense, a software application under copyright would be important to protect the look and artistic elements of the this thing of your website. Also, you would consider filing a application for artistic work under copyright. So these are some of the things I can think of on top of my head. But of course, it'll have to be properly considered before you go into this business.
Okay. The next question is, sir, can you explain about GI tags? Sidlingaya Hirimet has asked.
Again, not my area of expertise, but an example, like I said, the Kolhapuri chappal, which is like me being a Maharashtrian, is something which I grew up, wearing, because some of my family members come from Kolhapur, and they used to, whenever I visited there, I used to buy these particular chappals, and because that was that particular leather, and the material, and was something very different from what is available abroad. So this particular thing, this particular for GI's particular for Kolhapuri chappals, we've got our GI registered. So that is one example which I could give in that sense.
Okay. The next question is, what is the difference between IP and IPR? Asked by Pooja.
So IP is just intellectual property in general, and IPR is the rights which are available. So actually, it's just can be interchangeably used.
Okay. Thank you, sir. I hope the answers were satisfactory to all of you. Thank you. I now request our beloved principal, Dr. Uma Nirle, madam, to give presidential remarks.
Yeah.
Over to you.
Yeah. Thank you, Neelochana. Thank you, sir, being with 1 hour with us, and spending a very quality time with us, and in a very simple way, what are the different types of the IPR you have explained, the basic things. So in every book, especially we the educationalist, always seeing the copyright, and very two common examples you have taken. Those can be understood by our students, that is Coca-Cola and KFC patents. So whatever may be the small work or the big work, we can protect our work through these all the trademark or the copyrights. And being India is a common law country, it also follows the coded laws also, and there will be the infringement actions on such a copyrights or something. So sir has given a different websites also, so the common man can register himself or herself for their small work, whatever it may be, and how we can protect our writings or paper publications or music or whatever the product. Sir has explained wonderfully. I on the behalf of our all the students and our teaching staff, I extend a grateful thanks to the sir. Thank you, sir. Thank you.
Thank you so much, ma'am. Thank you. It was very nice being here. Thank you.
Thank you, madam. I deem it a great honor and privilege to propose vote of thanks on this memorable occasion on behalf of KLE Society and SK Arts College and HSK Science Institute, Hubballi. First and foremost, I thank our special guest and today's resource person, Shri Vikramaditya Chavan sir, for presenting such an informative session. Heartfelt thanks to you, sir.
Thank you. Thank you.
We are grateful to our beloved principal, Dr. Uma Nerle Madam, for her unstinted support for this workshop. Thank you, Madam.
Thank you.
I extend my gratitude to Srimati Prabha Munvalli Madam, Head of the Department of Political Science, for organizing such a wonderful workshop. Thank you, Madam.
Thank you. Thank you.
I also thank the technical team, Dr. Siddesh MB and Sunita Patil. Thank you, sir and madam. At last, I take pleasure to thank the faculty members, delegates, and all the students for making this workshop success. Thank you, one and all. Now, I request all the participants to switch on your cameras so that we can take a virtual group photos. The feedback link has been given in the chat box. You can fill the feedback. I request participants and the resource person, please switch on your cameras so that we can take a virtual group photo.
Thank you.
Thank you one and all. Shall we end the meeting, sir?
Right, ma'am, right. Let them fill the feedback and.
Okay.
Thank you, sir. Thank you.